All right, I'm Michael Henley, the CEO and founder of Brandywine Private Wealth. I'm joined by Matt D'Amelio, one of the top trust and estate attorneys in the industry. And today we're going to talk about general estate planning and kind of what to be aware of. So let's jump right in, Matt. For general estate planning, how often should an estate review actually be done?
I'd like to advise clients that they should have their documents reviewed every 3 to 5 years. And that's if nothing's happened. Obviously, if there's a major life event, you would want to go see your trust and estate attorney to see if that would require some change. You know, if, for example, one of your named executors passed away or one of your named agents under your power of attorney passed away, you would want to obviously change that. But over the period of 3 to 5 years, we find that enough little things that you may not think as being significant at the time, but in the aggregate, enough happens that it will necessitate some changes.
Okay, no, that's great. For Brandywine clients, as you know, we do like a pretty thorough estate review every 2 or 3 years. As tax laws are written in pencil, they never stop changing. I think that's still a pretty good idea.
I think that's a great idea and a great benefit to your clients. The advisors are usually, the financial advisors are usually the first line of defense to identify whether or not some changes are necessary. So the more frequently that you have those conversations, the better.
Got it. How often do you observe advisors are actually joining clients in their estate reviews?
Probably not as much as they should. The advisors tend to know so much more about clients that we like to know as much as we possibly can about our clients, but we don't have the same frequency of contact that the financial advisors do. So your presence in the meeting will very often reveal information that we haven't been able to get from the clients or just don't know. I've had advisors pipe up and say things like, "Oh, well, that's not his daughter." Right, because the client, they've had these children for so long, they didn't even tell me that, that's not actually a child of one of the clients. So the financial, that's perhaps a silly example, but although it has happened, those are the kinds of things that advisors can really add value with at the meetings.
Okay, no, that's great. Sometimes clients will ask, Matt, I have a will in place. Isn't my estate plan all set from here?
So a will is a part of an estate plan. There's so much more to it. At the basic level, everybody should have a durable power of attorney to appoint somebody who can make financial decisions for you if you can't make your own. Otherwise, someone's going to have to go petition a court for guardianship, which is time consuming and expensive. Of course, everybody should also have advanced healthcare directives, so appointing somebody who can make medical decisions if you're not able to make your own. And then depending upon where you are, you may want to avoid probate, and you would do that using a revocable trust. That's the basic plan, those 4 documents. And then depending upon the level of wealth, you layer on top of that with more complicated trust planning strategies.
Just to recap, the 4 basic documents are your will, your medical directive, durable power of attorney, and then revocable trust?
That's correct.
Okay, got it. Talk through just the basics around asset protection. For example, like a rental property that's free and cleared, should that be owned in an LLC perhaps, as opposed to the client's individual name or joint name?
Yeah, a lot of people like to use LLCs or other corporate entities for liability protection with rental property. If something happens there, you don't want your own assets to be available to creditors. Instead, you want to limit the liability to just the property itself. And so an LLC will do that. We have clients that have a number, with real estate, a number of LLCs where they isolate the liability to each individual property.
Let's talk about gifting. Annual gifting versus lifetime exclusions. A lot of times clients will ask, Matt, I want to give my son or daughter a couple $100,000 for a down payment for a house. And they'll often say, hey, I don't want to pay any gift tax. Am I allowed to do that? How does that actually work? How does the annual gift exclusion work relative to the lifetime gift exclusion?
Yeah, so that's a common question. And a lot of clients will come in and say that they want to gift their son or daughter, a sizable amount of money, but they think they can't because it exceeds the annual exclusion. So there's 2 exemptions or exclusions that you have to be aware of. The first is the annual exclusion. That's the amount that you can give anybody in the world each year without even having to report the gift, right? The
That's
IRS.
The $18,000 where it expires every December 31st, I guess?
That's correct. It's currently $18,000. It's adjusted for inflation in $1,000 increments over time. You can leave that to or give that to whoever you want, and of course spouses can combine for a total of $36,000. The second exclusion is your lifetime exclusion. Right. And so that is currently $10 million adjusted for inflation, which in 2024 is at roughly 13.6 million. That's scheduled to change in 2026 if there's no congressional activity, down to $5 million adjusted for inflation, which we think in 2026 is, ballpark $7+ million per person.
So just to clarify, if I give $13 million down to my daughter Savannah, I don't pay any gift tax?
That's correct. So until you exceed that lifetime exemption, then you don't pay any gift tax, or if you die, estate tax. Now, if you gave $13 million today, you would only have roughly $600,000 left to use at death. Any gift or during lifetime, or what you leave to someone at death, in excess of the exemption is going to be taxed at 40%.
Got it. So the $13.6 million you can either use during your lifetime or at death.
That's correct.
Well, thanks everyone for joining us. If you have specific questions on this topic or any other estate planning questions, feel free to scan the QR code to see how we might be able to help.